Welcome. This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation. Thank you. So without any further ado, I would love to move into introducing our panelists for this afternoon. Please feel free to join us here on the screen, panelists. It's my great pleasure to first introduce Judge Victoria Wood. Judge Wood is a retired judge from the Napa County Superior Court. She's known for her expertise in mediating high conflict cases with compassion and with patience. During her tenure on the bench, she presided over a wide range of cases, including civil, probate, family, criminal, juvenile matters, and she held key leadership roles. She was assistant presiding judge there at Napa Superior. Before her elevation to the court, she served as a commissioner, and prior to that, as a court research attorney. So she brings nearly 2 decades of court experience, all in all. Now a full-time mediator, arbitrator, referee, and temporary judge with ADR Services, Inc., Judge Wood's ability to resolve complex disputes with creative solutions has earned her widespread respect in the legal community, and she's able to resolve even those most emotionally charged matters. So thank you for presenting for us today, Judge Wood, and for joining us.
Okay.
I will turn it over to you to introduce our other fantastic panelists this afternoon.
Thank you, Katie, and good afternoon to everyone. Thanks so much for being here. I'm glad to see we have a lot of participants, a few hundred, so I'm glad to know it's a topic of interest to attorneys across the state. We have structured the discussion today into 2 parts. In the first part, we're going to give an update on the status of cannabis laws at both the federal and state level, and there's been some interesting things happening on the federal level that we will touch upon. And Katie, I think we were going to start the slides. Am I just not seeing that? I'll introduce Lauren in a moment.
Oh, apologies. I did want to mention one more thing before I get the slides up for everybody, that this will be somewhat of an interactive program today. So we will be launching a couple of polls throughout the program. Please keep your eyes peeled for those. You'll have maybe 10 seconds to respond to them. So keep an eye out for the poll coming up, and please do interact. We'd love to see what you think of those questions and answers. So thank you, Judge Wood. I will pull the slides up here.
Thank you. So yeah, as I was saying, it's going to be divided into 2 parts. So first part, we're going to address the status of cannabis laws at both the federal and the state level. And then we'll touch on some current concerns regarding the illicit market and the effect it has on the legal cannabis industry in California. In the second part of the discussion, we're going to address various areas of law in which attorneys who may not normally deal with cannabis might nevertheless see some of these issues cropping up on your caseload. And that's going to include the areas on the slide there: employment, torts, real property, landlord, tenant, environmental law, contracts, and some corporate law as well. But before we get started, I do want to introduce my co-presenter, attorney Lauren Mendelsohn. Lauren is a graduate of the University of California, Irvine School of Law. She's a partner at the law offices of Omar Figueroa, which is a boutique firm in Sonoma County that's well known for its specialization in cannabis law. Lauren has focused her entire career on this area, written an abundance of materials, spoken extensively on the subject. She's also been recognized for her work and expertise through numerous honors and awards, including being named as a Super Lawyer Rising Star, a Lawyer of Distinction for Sonoma Magazine, and most recently as a Top 40 under 40 in the North Bay Business Journal. So I feel really fortunate to have Lauren here presenting with me today. This is not an area of expertise for me, so I was able to learn a lot from her in preparation for today's presentation. So thank you, Lauren, for being with us, and I hope everyone enjoys it. And with that, we are going to move on to the section on federal law. So as of today, cannabis is still included in Schedule 1 of the Controlled Substances Act, which means that it's treated federally as a drug that has a high potential for abuse with no currently accepted medical use. And that means that it's categorized, as President Biden mentioned in his speech recently, along with other drugs such as methamphetamine, fentanyl, and heroin. And so a lot of people are and have been pushing to have this rescheduled. But yeah, currently it's still illegal under federal law to sell it, possess it, and even use it. It's just that law is not really being enforced for the most part. In fact, there is congressional appropriations legislation that provides express protections preventing the DOJ from prosecuting individuals or businesses as long as they are complying with at least with the state level medical cannabis laws. I do want to note, though, that hemp is different from cannabis in this regard, and I want to turn to Lauren for a second to explain that a bit.
Indeed. So hemp and cannabis, they are the same plant, botanically speaking. However, the 2018 Farm Bill changed the definition of hemp and removed that from the Controlled Substances Act. And so currently under federal law, the definition of hemp, which is now not a controlled substance, are, in a nutshell, parts of the cannabis plant that have a delta-9 THC content of no more than 0.3% on a dry weight basis. So again, it's coming down to a percentage of this particular compound, delta-9 THC, which is commonly thought of as the psychoactive component in cannabis, although there's a little bit more to it than that. But that's going to become very important in a number of areas, and we'll discuss this further out throughout the presentation.
Okay, thanks, Lauren. So I think probably most of you have heard by now that the DEA has started the formal process to reclassify cannabis to Schedule 3. And that means once that's finalized, it's going to be classified federally as a drug that has less potential for abuse than a Schedule 1 or 2 substance, that has currently accepted medical use and that has low or moderate risk of dependence if abused. The change is going to require some time to go through the rulemaking process. It has been started, so we're in a 60-day public comment period that will extend through July. But it does appear really likely that it is going to happen, especially because the White House has been pushing pretty hard for it, and they've signed off on that change. The effects of the change in classification, it is going to lower some of the potential criminal penalties, but I understand it's not going to alter the marijuana specific mandatory minimums in criminal law. But probably the biggest change for the cannabis industry is that these businesses are now going to be able to take the federal tax deductions for their business expenses that they previously were not able to do under Section 280E of the IRS code. And that's obviously a big deal for business owners to be able to take their expense deductions. But it will remain illegal technically under federal law to sell cannabis. And so that there's still a lot of impacts on the cannabis industry. Lauren, you want to address some of those?
Indeed. So there's still a prohibition against interstate sales. Obviously, there's a lot of limitations on research that can be done on cannabis. There are currently a lot of challenges with regards to banking. It's difficult for many cannabis companies to get bank accounts because there is a lot of additional due diligence that the banks have to go through in order for them to be in compliance with various federal money laundering laws and so forth. And additionally, currently there is a lack of bankruptcy protection for cannabis companies, which is a big challenge. This might change, but it also might not with the move to Schedule 3. So it's kind of waiting to see how that's going to come down. It's also difficult for these companies to get access to capital and traditional loans. And so those are just some of the many challenges that the industry is suffering from right now, some of which would be alleviated by Schedule 3, but not necessarily all of them.
And because of all these remaining impacts, there's plenty of people who are still pushing hard, wishing for full federal legalization, but it doesn't really appear that that's likely to happen anytime soon in light of some pretty deep divisions politically, congressionally on the issue. So I'll turn it to Lauren to address California law.
Yes, so some background on cannabis law in California. So California was the first state to legalize medical marijuana when voters passed the Compassionate Use Act back in 1996. This is now codified in the Health and Safety Code at section 11362.5. The states of Washington and Colorado were the first states to go even further and legalize recreational use. California then legalized recreational use of cannabis with the Adult Use of Marijuana Act in 2016. And currently the main governing statute for commercial cannabis activity is called MALCRSA, the Medicinal and Adult Use Cannabis Regulation and Safety Act. It's found primarily, as you see there, the Business and Professions Code beginning at section 26000. This gives the framework for cannabis licensing, oversight, and enforcement of cannabis businesses. Other sections in the Health and Safety Code, as you can see there, beginning at 11357 through 11362.9, this provides a statutory framework for the individual use of cannabis. And so this includes adult use, cultivation activities, and possession limits, as well as the Compassionate Use Act, which talks about medical cannabis patients and caregivers. And regulation of the California's cannabis industry. It used to be governed by 3 separate agencies primarily. These were consolidated into a single agency in 2021 called the Department of Cannabis Control, the DCC for short. And those are some common issues. Next slide, please. And so one issue that is comes up a lot in cannabis licensing has to do with local control. So under MALCRSA, local jurisdictions have the ability to decide where, if, how many, and what types of cannabis businesses they will allow within their borders. Cannabis businesses do need to have both a state license and a local permit or other local authorization in order to operate legally. And based on data that has been compiled by the DCC on their website, right now only 46% of cities and counties in California allow at least one type of cannabis business. So that leaves many parts of the state that there is no access for individuals to go purchase at a licensed cannabis facility, or for individuals who want to work in a legal business. It's not possible in many parts of the state still. And there's different types of cannabis licenses in California. As just a quick overview, there's cultivation licenses, which have a few different subtypes. Manufacturing licenses, those also have a few subtypes. There's testing lab licenses. Distribution, which are the transporters, also the quality control and warehousers. Retailers, which we think of as dispensaries, but they can also operate by delivery. And micro business licenses, which is kind of combining a few different licensed activities under one roof. And there's also event licenses, both for event organizers and for the actual cannabis events themselves. And yeah, so I think, is there a point that you want to add here about this information that's on the DCC's website? And also I want to note that they just recently launched some very, very detailed data portals in addition to the map that talks about what's allowed where. They have recently published a vast amount of information about licensing numbers across the jurisdictions. And so I encourage everyone to take a look on the DCC's website for this information.
Yeah, that's just what I was going to add, that they have a lot of information there, including a graphic of which counties have businesses and which don't. I was surprised to see how many still don't at this point, but yeah, lots of information there. So I think we'll turn to the next issue, which is current market challenges for the industry. There are concerns whether it can remain a competitive market force while it has, heavier regulations than a lot of other business and tax burdens. And that's somewhat problematic at the state level because it has become part of our economy now. Last year, California recorded over $5 billion in legal cannabis product sales. So that's a lot of tax revenue and a lot of potential revenue for the future. So our state government is putting a lot of resources into regulating the illicit market. And we've listed there 3 agencies that have been formed, task forces that have been formed in the last couple of years to you can look up what they specifically do, but in general, they're all focused on combining federal, state, and local level resources to optimize their enforcement efforts. But it is still really a big challenge for the industry. I think I'm going to skip ahead in the interest of time. So regardless of what the future holds for the cannabis industry, when recreational use was first legalized in 2016 in California, there was a big onslaught of business formations and infusion of investment dollars. And what we're seeing now is that all those businesses that were formed are having various struggles and having legal interactions which means that attorneys are now going to be facing these issues, even if you're not practicing cannabis law specifically with the crossover. And so that's kind of the main point of the presentation today. So we will turn to part 2, which is our crossover issues. And we're going to start with employment law. And first, I'm going to touch on some big FEHA changes that occurred in January of this year. So it is important to understand it is still legal for employers to mandate that their employees do not use marijuana at work or be under the influence actively while working. And there's not any exception for medically prescribed use or anything like that. But what did change with these new laws is first off, it is now unlawful for an employer to discriminate against an employee or an applicant for a job for using marijuana off the job and away from the workplace, or to do so based on the results of an employer-required drug test. That's a drug test that screens for non-psychoactive cannabis metabolites in the system. So that basically means hair and urine tests, because those measure metabolized cannabis, and that can be detected for days or weeks after use and don't really accurately measure current impairment. So anybody who's advising employers needs to make sure they're aware of that. And then the other big change to FEHA, January 1st of this year, it's also unlawful for an employer to inquire about a job applicant's prior cannabis use, including as it relates to criminal history. So if an employer is going to ask about an applicant's criminal record, they need to make sure to accept out of that inquiry convictions related to marijuana use. Marijuana use is the term in the statute, but I wanted to turn to Lauren to get your opinion on whether you think that would apply also to criminal convictions related to possession as opposed to maybe sales and so forth.
That's a good question. As you noted, the language is specifically about use. I think that because certain activities could have use kind of associated with it, it's a bit of a gray area. I think if I was an employer, I would err on the side of not asking that type of a question if there's any way to avoid it. However, he's still going to wait to see how this all plays out in the courts and how a judge would actually rule on that question.
Yeah, it's brand new. One quick note, both of these amendments do carry exceptions for certain types of employers, and that includes employers in the building and construction industry, and also those that require federal background screening and clearances. So we are going to turn to a little hypo to mix things up a bit. So you have an employer who suspects an employee is actively high on the job on marijuana and demands that the employee provide a urine sample for drug testing. Aware of the new FEHA regulations that we just discussed, the employee refuses to test and then an adverse employment action ensues. Has FEHA been violated by the employer? And we'll give you a few moments to enter your polling results there, and I'll have Lauren take over the answer when we're ready. So we've got 213 people answered, and it's really close. So 54% of you say yes, 46% of you say no. Lauren, what are your thoughts on that?
So technically, the new law only pertains to cannabis, and it only prohibits discrimination based on testing positive for non-psychoactive cannabis metabolites. The employer could argue that it planned to use this test to screen for other drugs, which isn't prohibited under the new regulations. There could be an evidentiary problem there if the test was prompted by believing the employee was under the influence of marijuana. So the best policy would be for an employer who wishes to test for other drugs to make that clear in writing. And if the concern is actually active impairment on the job, then the best bet is for the employer to use a test that's going to detect for those active cannabis metabolites, or they could focus on performance issues that might be arising as well.
What are the tests that they can use? Some examples.
So there's certain actually breath tests. A blood test is going to be the most thorough, although it is a bit invasive.
And saliva too, I understand.
Saliva, yeah.
Yeah. Okay. Thank you. And this is just our opinion. We don't know how it's actually going to play out, but it's interesting to think about. So, all right, Lauren.
All right, next we're going to discuss some workplace safety issues that are related to cannabis businesses. So cannabis businesses, in order to get and maintain a state license, they do have to have, if they have 2 or more employees, they need to have at least 1 supervisor and 1 employee complete a 30-hour Cal OSHA training course by an authorized provider. Additionally, if we're talking about risks within the workplace, these are going to differ by cannabis license type and employee role. And these include, but are not limited to, inhalation of potentially harmful chemicals and particulates, handling of potentially harmful chemicals, injuries from repetitive motions, motor vehicle injuries, other machine-related or equipment-related injuries. Also exposure to heat, if we're talking about people working outside, exposure to smoke for in a wildfire area, and a number of other workplace safety concerns that arise just in general workplace settings. So those are some of the ones that arise in particularly often in the cannabis space. And therefore, it is important for licenses to follow appropriate recommendations, requirements, and best practices. Cal OSHA has a webpage specifically for the cannabis industry that compiles a lot of this information and resources for licensees right there. And also cannabis consumption lounges, they're a hot topic right now. And these are allowed under Malcursa. They do need to be allowed by the local jurisdiction in order for you to open one up. And these also have unique workplace safety concerns related mainly to indoor clean air laws and regulations and ordinances. So for example, California Labor Code sections 6404.5 prohibits employers from allowing smoking in an enclosed space in the workplace. That would theoretically be violated if an employer is allowing smoking to occur in an enclosed area of their facility. Now there is an exception here for retail or wholesale tobacco shops and private smokers lounges, but this does not, at least not yet, include cannabis lounges. There is potential penalties and liability for employers in these settings. And so that's something to note. Additionally, there is some legislation right now, a bill in Sacramento, that would allow consumption lounges to prepare and sell non-infused foods and beverages. Currently, consumption lounges are only allowed to sell prepackaged food and beverages in addition to the cannabis items that they provide. This bill is advancing despite a veto last year from Governor Newsom, who was concerned specifically about employee exposure to smoke in the lounges. So the new bill has clear division of the food preparation and main employee work areas versus the areas where patrons will be consuming and smoking over there, to an attempt to separate those out as much as possible.
Okay, thank you. If I wanted to just touch on one question that we have in the question and answer that you might be able to weigh in on, Lauren. There's a question as to whether there's any indication on whether the ability to deduct expenses will be backdated to prior tax years. Have you heard anything about that?
I have not. That is a very good question, and I would imagine that that's going to be analyzed if it hasn't already been in one of those many reports that's come out in the past few days. Then I'm sure that'll come up in the near future. If that, my guess is that won't be the case, because that is really going to open up a very large can of worms. And when is the cutoff date and things of that nature. But we'll see. That would certainly benefit a lot more operators than it not being retroactive. So good question. I don't think so, but we'll see.
Okay. All right. We're going to move on to the next area of law, which is tort law. Feels a little bit like we're back in law school. We're going to start with product liability issues and where civil counsel might see cannabis-related issues arise in this context. Of course, you might see defective products. I think most people have heard about issues with, for example, the electronic vape devices exploding and people's faces or in their pockets and whatnot. You might see contaminated products, for example, products that have high pesticide levels. And if anyone's interested in this issue, there was an article, an investigative piece that was pretty thorough. It was published in the SF Gate in February, and it addresses some real concerns about pesticide levels in the product. The conclusion is it's a result of the DCC failing to have established a solid protocol for testing and enforcement. And there's even some concern that there are labs doing the testing and just reporting false results, inaccurate results. So definitely some areas to clean up there. And it does seem pretty clear that there probably are some contaminated products out there on the market that can cause harm to the public. So I think lawyers are going to be seeing some of those issues. You can have liability arising from misrepresentations in the labels and advertising. For example, if they state inaccurate THC levels, or maybe they say that the product is CBD, not THC, and that's not exactly correct. You could also just have negligent representation, for example, an employee who just kind of mixes up the labels on the different types of products. So we'll stop there with another quick hypo.
And if maybe I can just add one quick note, recently the DCC has issued a number of recalls, and you can, on the DCC's website, you can read about all the current and past recalls and why the products are recalled. There's a number of products now that are contaminated recently with mold. So that's a common contamination issue as well.
Okay. All right. So you know what? I'm looking at a time check. We're going to skip this hypothetical because we don't know the answer, but this involves a case that's going to go before the United States Supreme Court about whether this issue can proceed under RICO laws. And I'll just tell you the name of that case for those who might be interested. It's Horn versus Medical Marijuana 2023, and that's at 80 4th 130. 80F 4th 130. So you can look into that separately. All right, Lauren, let me turn to you for the next tort issues.
All right, so some additional bases for tort liability. These can include secondhand smoke injury claims. Smoking laws do apply to marijuana smoke the same way that they do to tobacco smoke. So you need to make sure that you are far enough from doorways and not consuming cannabis smoking where there's a no smoking sign. Employers and landlords also must not allow smoking in enclosed employment, as we noted, or also in multi-unit housing areas that would expose others to secondhand smoke. And if employers or landlords designate smoking sections, but they fail to strictly follow all requirements, such as distance from doorways, as I mentioned, they could face liability themselves for secondhand smoke injury claims. Also, there's the issues regarding failures to warn. In particular, this comes up with Proposition 65, which is a California law that's not specific to cannabis, but both cannabis smoke as well as THC are on the Prop 65 list. One is on there for cancer, one is on there for reproductive harm. And Prop 65 requires businesses to provide clear and reasonable warnings about significant exposures to chemicals that cause birth defects or other cancer or other reproductive harm before exposing consumers or employees to those products. And in addition to marijuana smoke and Delta-9 THC on the list, there's also some terpenes that are commonly found in cannabis that are on the list as well. And so cannabis companies have to comply with these requirements for warning, and they're also susceptible to claims involving failure to warn. And it doesn't matter if a company is based in California, only if their products cause exposure here in California in order for these warning requirements to be triggered. There is specific safe harbor warning language for cannabis goods and consumption lounges that can be used in order to satisfy the clear and reasonable warning requirement. And there is an exemption under Prop 65 for small businesses. So if you have fewer than 10 employees, there is an exemption there. Another base for tort liability could involve improper sales or advertising to minors. So Malcursa prohibits cannabis goods and marketing about cannabis from being attractive to children. And this includes, but is not limited to, restrictions on the use of words like candy, whether it's spelled correctly or incorrectly. Also the use of cartoons, images, or characters or phrases that are usually used to market to children, as well as imitations of actual candy packaging and labeling. Furthermore, licensees may only advertise using a particular method if they have reliable data to indicate that at least 71.6% of the audience receiving that information is at least 21 years old. And the DCC regs require age verification if there's any direct individualized communication or dialogue. So an email list, you need to verify your age first. And also there's rules about not selling cannabis to minors, and retailers do need to make sure that they don't sell to minors. And there's also restrictions on how much they can sell to each customer a day. And as we noted previously, consumption lounges also present unique tort risks. And so a few other tort risks that could arise in a lounge context. I think that I'm going to turn it over to you, Judge Wood, to talk about some of these other issues that can arise in a lounge context.
Sure. Yeah. So, you can have things happen in the lounge where maybe you have a patron who gets out of hand and causes injury, or a patron who has a bad physiological reaction to a product, and also maybe inadequate Prop 65 warnings. And sort of the question there for me is, if the consumption lounge is not really able to fully comply with the law, then they may have liability for any of these things that happen. And maybe you could be looking at negligence per se, because they're violating a statute in the process of that tort occurring. So that's just, I don't know the answer, but something for counsel to keep in mind. Yeah, let's see. All right. So we will move on. Oh, we do have a hypothetical. We'll do this one real quick. So you have a 17-year-old who manages to purchase a THC product from a dispensary. After ingesting the product, the minor is at fault in a car accident that injures a third party. We'll do a poll to say, is the dispensary liable here? Just another minute or a few seconds here. Okay. So it looks like 76% of those who participated say yes, 24% say no. I don't know the answer. We don't have a case that I found, but I think that it would follow the analysis as sales to minors of alcohol and when they're involved in accidents. I don't see why it would be handled differently than that. So my vote is yes. If we were interactive, I'd love to hear the reasons for no, but not going to be able to do that today. Okay, we are going to move on to some real property landlord tenant issues. I'll turn it back to Lauren.
All right, so first in this subsection, we're going to talk a little bit about nuisance claims and the right to farm. And we also, this touches on hemp, which we mentioned previously, but California's right to farm law, which is codified at Civil Code 3482.5, protects agricultural operations from nuisance actions, provided that activities are conducted in a manner consistent with proper and accepted customs and standards. And certain counties, such as Sonoma County, where I'm based, they have their own right to farm ordinance in addition to the state law. Now, because cannabis is not considered an agricultural crop or a commodity under state law, but rather an agricultural product, it's not afforded protections given to other agricultural operations. And therefore, cannabis farms are subject to nuisance lawsuits related to odors, pesticide drift, pollen drift, etc., that other agricultural operations may not be subject to. And so we can compare this with hemp, which, as I mentioned, is botanically the same plant. It looks and smells the same, but has a different delta-9 THC content, which hemp is federally legal. It's considered an agricultural crop, and it can take advantage of right to farm protections. However, cannabis cannot. And so I believe we have got a hypo for this one. Yes. So the farm next door to your client's property is growing what your client believes to be cannabis, and they find the odor bothersome. However, your research reveals that the farm has a valid hemp cultivation licenses from the county and state. Is your client likely to prevail on a nuisance claim? So it looks like about roughly 1/3 said yes, roughly 2/3 said no there. And given the federally legal status of hemp and its classification as a crop, if all that was happening was hemp cultivation, then they're unlikely to prevail on a nuisance claim rather. However, if any of the hemp was actually cannabis because it had more than 0.3% delta-9 THC, or if they had a little bit of cannabis in the middle of the hemp farm, then the right to farm would not apply, and a nuisance claim could be possible there. So kind of a yes and a no. Depends on the facts.
Nice, as always, right? So some considerations to watch out for those who represent landlords who might be interested in leasing their property to cannabis business. It is a violation of federal and state law to lease a property to be used for activities that violate the Controlled Substances Act, and the potential penalties include asset forfeiture as well as civil and criminal charges. So Lauren, since it's still federally illegal, doesn't this mean that all landlords are kind of at risk, even if they're renting to a state licensed cannabis business tenant?
It does, yes. And so that's why many landlords are not willing, even to this day, to lease space to cannabis businesses. And typically, if they're a savvy landlord, they'll be asking for a limitation of liability and indemnification language and other sorts of assurances in their agreements with their tenants that, to the extent possible, they will not be held responsible. Also, they will, again, if they're savvy, require that any activity be done in full compliance with state and local law, as that will make it less likely for a federal action to take place.
Thanks. And then California law requires that a landowner affirmatively authorize any commercial cannabis activity on their property. So they would have to provide their name and contact information to the DCC in order for the cannabis license to be issued. So it's not a hands-off proposition for the landlords by any means. If they allow unlicensed activity, they're subject to penalties. There's a lot of standard leases and insurance policies that include language prohibiting any activities that violate federal law, which all commercial cannabis activities do. So it's going to be important to review the fine print on those types of agreements and policies on behalf of the landlords. And then local jurisdictions can impose penalties as well. So bottom line, Lauren, it seems like if these attorneys have clients who are interested in renting to a cannabis business, it would behoove them to consult with someone who has more of an expertise in cannabis law. Would you agree?
Absolutely, yes. And I've worked on both sides, on the landlord side and on the tenant side. And they're little words and little phrases can make a very big difference, as everyone here knows, but it's particularly important in this space when we're dealing with something that's still federally legal. So, you know, one thing that I want to talk about while we're discussing this has to deal with, again, potential liability for landlords. There is the issue also of liability for local code enforcement violations, code penalties, and things of that nature. So, but there is a defense, this innocent landowner defense. So just for some background, there's law, California Government Code Section 53069.4, and this allows local agencies to immediately impose administrative fines or penalties for violations of zoning restrictions, plumbing or electrical or other structural type violations, if these violations exist as a result of or to facilitate unlicensed cannabis activity. And there's an exemption for lawful patient activity and licensed business activity. But this law also allows the local agency to hold the property owner and the business owner or the business operator jointly and severally liable for these fines and penalties, which can be up to $1,000 per violation, $10,000 per day, and a violation could be a single plant. So we're talking about very, very high potential fines and penalties. Now, there is, though, this defense, which I have the language on the screen, the innocent landowner defense. And this is important for anyone representing landlords to be aware of. And this does kind of have an exemption for landlords who are able to demonstrate that this tenant was in possession of the property that's the subject of the action, that the landlord had a rental or lease agreement that prohibited that cannabis activity that's now the subject of the action, and that the property owner did not know that this was going on and hadn't received any form of complaint or anything like that. So there is this limited protection for landowners, and this is in state law.
Okay, thank you. I know we kind of rushed ahead on that a little bit. So more details to be looked at. But let's move on to environmental law so we can at least touch on some of those issues, particularly CEQA concerns. Important to know that CEQA does apply to cannabis businesses, and that's because even just the process of getting a cannabis license is considered a project that's subject to environmental review. The bigger projects that would require like a full EIR are usually going to be the cultivator operations. Some of the smaller cannabis businesses like dispensaries, small dispensaries can probably comply with CEQA through less onerous processes like exemptions. But the businesses are required to be licensed by both the state and local governments, and all the agencies or municipalities that are involved do have to ensure CEQA compliance before they can proceed with their discretionary licensing or permitting decisions. So when you have multiple agencies, there's going to be one that's designated as the lead and the others will become responsible agencies. But the municipalities themselves also have to comply with CEQA when they are adopting local cannabis ordinances. And the municipalities can sort of approach this process in two ways. They can approach the secret review more broadly, which will make it easier down the road for the businesses to get through the CEQA process, but that means it would be a more onerous process for the municipalities up front and could face, some costly legal challenges. So many of them opt to do sort of the lesser review, the least that they need to do, but then that means that the individual businesses have more that they need to take care of on their end regarding CEQA. And so that's just something to be aware. Bottom line is, like, if you are counsel representing either the cannabis business or the municipality, or perhaps a person or an organization that wishes to challenge a cannabis project, just be aware that the CEQA review for cannabis businesses occurs at various different levels and stages. There's some other environmental considerations. Lauren, you want to touch on those?
Yes, so under Health and Safety Code 11358D3, this mentions how cultivation of more than 6 cannabis plants by an adult, while doing that by itself is a misdemeanor, if you do so while engaging in environmental damage, and it lists various different types of environmental damage, this can then be charged as a felony. So it's really important that you are taking care, your client is taking care of the property. And even if it's an individual adult grower, they could be some serious penalties for things like dumping into waterways and harming fish, etc. Additionally, permits and reporting is required by both the State Water Board and also the California Department of Fish and Wildlife to obtain and maintain a cultivation license in California. And there's different registrations that one needs to have in place for water quality, and also for any water diversions that have to be registered, and then a lake and streambed alteration agreement from CDFW, or their notice that such an agreement is not required. That's necessary to get a cultivation license. Additionally, Malcursa and the DCC's regulations have restrictions on water usage, renewable energy, use of generators, and other environmental related concerns that operators and counsel in the space should be aware of.
Okay, thank you. We're going to turn now to some contracting issues. You will have some breach issues that you'll see arise commonly with relation to product purchase and service agreements. You might see breaches based on failure to properly store or handle products. You might see failure to manufacture according to the terms of agreement. You can see late or missing payments. Regarding premises agreements or leasing agreements. You might see failure to comply with the lease terms. Those 4 that I just mentioned, those should all lend themselves to, fairly standard contract analysis. The other issues, these that I'm going to mention now, they have some more special concerns related to cannabis. Like if you have a breach based on the failure to comply with local or state laws and regulations, and then regarding business formation, investment agreements, licensing agreements, these all have really unique issues related to cannabis, and Lauren's going to touch on those in a bit if we don't run out of time. Sorry, we're kind of cruising along here. There are some important contract considerations to keep in mind with any contracts that involve cannabis businesses that attorneys should pay special attention to. And I think this is the next slide, Katie. Since cannabis is still illegal at the federal level, there's going to be a stronger interest in keeping the details of any dispute confidential between the parties rather than disclosed in a public court filing. So that's going to make confidential mediation or arbitration preferable, arguably imperative for some of these companies. And then you're going to want to be really careful with your the wording of your ADR clauses, your forum selection clauses, choice of law clauses, because that can really significantly impact the result of these dispute because of not only the federal illegality, but the difference in laws from state to state. So if you have a client that is contracting with a cannabis company, be aware that those companies are likely to push to ensure that the contracts include a waiver of the right to remove it to federal court, again, because of the illegality. And then if you are going to be utilizing ADR, you're obviously going to want to try to select a mediator or arbitrator who's familiar with and comfortable with the cannabis industry issues. Lastly, I wanted to mention some added insolvency concerns for these companies. Their insolvency is somewhat perhaps more common for these businesses right now because of the extra obstacles they face regarding traditional financing, their inability to get some normal bank loans or business association loans. And so they're running into financial problems. And then, as Lauren previously mentioned, they don't have, at this point, they don't have bankruptcy protections under federal law. And so really, when they become insolvent, right now, their remedies are limited to receiverships, which we all know are a big and expensive deal, and also assignments for the benefit of creditors, ABCs as they're known, and those can have real complications as well. So just be aware of those issues. Lauren? Corporate law?
Indeed. So we're almost at the end here, just a few more topics to touch on. So I'm going to talk for a moment about some unique licensing restrictions that cannabis companies have to deal with, as well as some disclosure requirements. So in terms of licensing restrictions, under the DCC's regulations and NACRSA, cannabis licenses are not transferable to another person or another location. So as a result of this, sales of cannabis businesses that have licenses are typically done as a stock sale versus an asset sale. The entire company has to be acquired, and then you get the license with it. You can't just sell the license. Otherwise, the buyer is going to have to apply for their own state and local licenses, and that can take several months, if not longer. Furthermore, the DCC regulations prohibit a 100% transfer of ownership at the same time, meaning the individuals who are owners, you cannot swap out them all at the same time. At least one owner who's already been approved by the DCC has to remain as an owner on the license while other new potential owners are being reviewed and approved. Otherwise, the business has to stop operating until a new license is obtained. So this creates unique concerns when we're talking about, sales of businesses and how you're dealing with someone from the old team has to stay on. How are they going to structure that? If you have to buy the whole entity, what about the other liabilities that the buyer might not want to acquire? So it does create some complications there. With regards to disclosures, NACRSA requires disclosures of all owners and financial interest holders as these terms are defined in the DCC regs. All owners have to submit additional information and undergo a state and federal background check prior to being approved for a state license, and owners are listed in a public database that everyone can see. Financial interest holders have to be disclosed, but they don't have to get fingerprinted, and they're not listed publicly. So under NACRSA, an owner, and this definition is in section 15003 of the DCC's regs. This includes any person who holds a 20% or more equity interest in the licensed business, as well as anyone who exercises direction, management, or control over the license. And this includes, but is not limited to, officers and directors of corporations, also managers of limited liability companies, as well as I mentioned, someone who has a 25 or 50% actual ownership interest. So that's an owner. Financial interest holder is a different definition, slightly lower threshold. This is section 15004 of the DCC regs. And this includes a person with an aggregate ownership interest of less than 20%, person providing a loan to the cannabis business, a person entitled to receive 10% or more of the profits of the commercial cannabis business, including, and there's a few different examples, an employee who's entered into a profit share plan with the commercial cannabis business, a landlord who's entered into a lease with the commercial cannabis business for a share of the profits, a consultant who's providing services to the commercial cannabis business for a share of the profit, also a person acting as an agent like an accountant or an attorney for the commercial cannabis business for a share of the profits, a broker who's engaging in activities of the business for a share of the profits, a salesperson who earns a commission, and a person who's entered into an intellectual property licensing agreement with the commercial cannabis business for a share of the profits. Now, a financial interest holder does not include any of the following: a bank or a financial institution whose only interest is a loan, person whose only financial interest in the commercial cannabis business is through an interest in a diversified mutual trust, mutual fund, blind trust, or a similar instrument, persons whose only financial interest is a security interest, lien, or encumbrance on property that's going to be used by the commercial cannabis business, or persons who hold a share of stock that's less than 10% of the total shares in a publicly traded or privately held company. So that is, again, section 15003 and 15004 is where you can find those. And that's important if you are going to be advising anyone who might be deemed a financial interest holder or an owner of a commercial cannabis license, that you're aware of what those definitions are. And we do have a hypothetical for this.
You know what, I think maybe it's 12:57. Maybe we can skip that hypothetical and look at some of the questions. I noticed there was a little bit of maybe confusion about whether our first hypo, whether it there was a FEHA violation in that example. And I would say yes, if the employer was trying to require that kind of test for the purpose of testing for marijuana use, then I would say yes, the fact that they didn't actually administer the test wouldn't change that outcome. So the bottom line is, when an employer wants to do testing, they need to use the right kind of test. Or if they want to use, for example, a urine test, make it clear we're not looking for marijuana use. I think there are that laboratories are now offering tests that actually exclude the results of marijuana in response to this new regulation. So, and have you had a chance, Lauren, to look at any of the questions in the chat? I did see somebody pointed out that if in the hypo where the 17-year-old was able to get cannabis, if they had used a fake ID that was realistic enough, then the dispensary probably would not be liable. I agree with that. Someone asked about whether the information about leases applies to residential leases. You want to respond to that as best you can real quick?
Does this apply to residential leases? If I'm not sure exactly what the question is in regards to, if it just means in general, whether it's a violation of federal law to lease to an individual who is just growing for personal use. Yes, technically, cultivation of a single cannabis plant is still a violation of federal law. And it's important to note, even if it gets rescheduled to Schedule 3, it's still illegal unless you have a DEA license to produce or distribute cannabis. It's not going to be federally legal. It is just going to modify the classification and make certain things easier to do. But it would not change the laws with regards to landlords or potential asset forfeiture involved with cannabis properties.
So we have a lot of good questions remaining, but it's 1 o'clock. So I think we need to stop there. I know that was a lot of area to try to cover in 1 hour, but hopefully it's going to be helpful, at least for issue spotting any of these concerns. I hope you enjoyed it. And if you have more questions that we couldn't get to, you're welcome to email me or Lauren. I think we had a slide with our email addresses. You can get my information on judgewood.com too. That's probably the easiest way to find my info. So thank you again to everyone for joining us.
ADR Services, Inc. has been your unwavering partner in alternative dispute resolution. But as the world changed, so did we. From virtual and hybrid hearings to our ongoing on-demand CLE program, ADR Services Inc. continues to keep resolution and legal education at the forefront. Woman-owned and operated from the start. There is someone for every situation. We are ADR Services Inc.